My name is George Thompson. I'm the Director of Education here at the Law Society, and I'd like to welcome you this morning, once to get you all seated, to the program on causal connection. If I could just at the very beginning deal with a few administrative matters. First of all, one thing I need to tell you is that we're going to press the program a little bit, compress it a little bit, and push you fairly hard in terms of getting from one thing to another so that we can be done at a reasonable hour this afternoon. There's a swearing-in ceremony this afternoon that's going to mean we're going to lose a number of our people, and so we are trying to work our way through so that we can be through the program about 3:30 this afternoon, 3:45. To do that, another reason is that we want to allow more time for the causal connection debate that's taking place this morning than is allowed for in your schedule. So we'll move at a fairly fast clip, and when we get to the workshops, we'll be asking that you go and get your coffee and head straight off to your workshop, because then we can start that and we can have a shorter time left for the morning break. I'd also like to mention that if you could come back sharp at 1:45 after lunch. We have some entertainment from Carole and the carriage trade at that point before we move into the afternoon panel, and we would like to have everybody back sharp at 1:45. That will also enable us to be done by the time we've suggested. One other thing, you will be going into workshops this morning to work on two causal connection problems in workshops headed by a judge and a lawyer. When you go out of the door, if you've not already been given the room you go to, the workshops are listed and the rooms are listed with the people in each workshop on the glass out there or on the door, beside the door leading into the bar admission course office out in the hallway. If your workshop is number 200 and something, that means you go down that way behind us here and up to the second floor. If you go up the escalator, you'll end up one floor higher than you want to be. If you're 300, then you do go up the escalator and turn to the right and you find 300 and something. If you're in room 330, it's the room nobody can find. It's to the left of the upstairs lecture hall. In other words, when you get upstairs, there's a lecture hall there. It's to the left rather than off where all the other workshops are. So if you're in room 30, that's where you go, or ask if that wasn't clear enough. Just two other things, if I could. It tends to be the case here that family law programs, when they're put on by the Law Society, are 2 or 3 times as demanding as any other kind of program, both in terms of preparation and work that has to be done to produce papers and organization of the program. And this program has been no exception. And so I want to, at the beginning, thank, on behalf of the Law Society, those people who have given inordinately of their time over the past almost 4 months now as we've put this program together. They're listed at the front of your program, but if I could just acknowledge the work they've done. The planning committee has been composed of Phil Epstein, who's with the firm of Epstein and Cole, Stephen Grant from Gowling and Henderson, Jennifer MacKinnon from Burke Robertson in Ottawa, Evlyn McGivney from Bastedo, Cooper and Shostak, Paul McInnis, who's to my left, I'm about to introduce him, from Shibley, Wrighton and McCutcheon, Monique Metivier, who's a lawyer in Ottawa and the chair of the Ottawa version of this program that will be held, the chair with Jennifer of the program that will be held in the next short while, and Professor Carole Rogerson from the Faculty of Law. All of them will be introduced more extensively when they make presentations or do other things today, but I simply wanted to acknowledge the tremendous amount of work that they've done on the program. And I'd also like to do 2 other things. Secondly, to thank the lawyers and judges who have given of their time to be part of the workshops that we're going to have this morning. And then finally, in addition to your book, you've been given a copy of a publication that's not yet published, but is about to be, which is as good an analysis as I think you're going to find anywhere of the economic implications of marriage breakdown and divorce. And it's been prepared by the Canadian Research Institute for Law and the Family. Marnie McCall, one of the 2 authors, is here today from Alberta. You're being given free of charge a pre-publication copy. I highly recommend it to you as a document that will help you in making submissions to the court dealing with that issue in the future. The program is going to begin with a presentation from Paul McInnis. We've structured the first part of the day so that you will be given an overview of the law followed by an analysis of the law in a broader context, followed by a debate on the issues of causal connection before you move into workshops where you will be asked to make a decision on 2 cases that will be given to you in the workshop. And then you'll come back this afternoon and there will be 2 judicial panels analyzing specific problems that are included in your materials. Paul McInnis will go first. Paul is a graduate from Queen's University, called to the bar in 1979. He's a partner with the firm of Shibley, Wrighton and McCutcheon and a specialist in the area of family law. Paul is perhaps the earliest writer in the field on the issue of causal connection, having produced a very helpful paper for the Advocate Society Journal in the spring of 1988 called The Emergence of Causal Connection, and he's also been part of our Lexitel conferencing program speaking on causal connection. There's probably no one who has kept up on causal connection more than Paul has, and he has prepared what I think you will find to be the most up-to-date and complete chart of all cases on causal connection decided over the past 2 or 3 years since the concept emerged. And Paul will begin by providing you with an overview of the concept, and I'll turn the program over to Paul McInnis.
Thank you, George. Can everyone hear me? Is that fine? It's going to be next to impossible to do an overview of causal connection in about 20 minutes. What I'm going to try to do in the time that I have is to illustrate some trends which seem to be developing and try to take you from a very simplistic first step to some indication of where we might be going. The presentations that follow today will be very intensive in terms of expressing views, and the hope is that by the end of the day you will have your own view. There's not necessarily a right or a wrong view, but I think one of the primary views that we came away with as an organizing committee and that we hoped that would be left with the registrants would be that causal connection is still emerging. It has not arrived. It is a principle that can be argued at a threshold level on support applications and interim applications, that it shouldn't simply be accepted as a principle. If it is to be applied, we hope that you will have from this seminar the ability to argue effectively either for it or against it without precluding your opportunity to argue that causal connection does not exist as a prerequisite under either the Divorce Act or the Family Law Act. And I think that without speaking for the others directly, is the philosophy that we have taken from our organization. Now, what exactly is causal connection? And in the review of the cases that I have made, it's been described as a number of different things. It's been described as an issue, a consideration, a test, a condition precedent, a prerequisite, a requisite, a principle, a concept, a theory, a requirement. All of these descriptions have been used to describe what has been affectionately called causal connection. Looking at it on the basis of a strict definition, causal means, by definition, an interaction of cause and effect. Connection, by definition, means a logical relationship, so that we can assume from that this concept of causal connection is really a logical relationship between cause and effect. The cause being something arising from the marriage, the effect being the need. essentially, if you can't prove that this link or this relationship exists between the need and the marriage, then you haven't satisfied the test and you're not entitled to support. Some would describe the emergence of causal connection as an evolution of the principle from the initial trilogy reasoning in the summer of 1987. Others would probably describe it as a regression. I have prepared the materials in two forms. The first part of my materials are really an expansion of the paper that I wrote back in the spring of 1988 for the Advocate Society Journal, which was a much easier paper to write because there were only about a dozen or so cases that had been decided at that point in time, and they were essentially divided. Since that time, I have counted some 36 cases that have been decided, and there are numerous other cases, and I'm sure that many of you have been involved in cases where causal connection has been applied or has been argued that haven't been reported, or you're aware of other cases. The second part of my material is a table of cases which I've prepared simply as a compilation of the law. I've always liked leaving these seminars with either tables of cases or checklists, and hopefully this will provide you with a mechanism, a quick read mechanism, where you can review very quickly the cases to see if one or more cases might apply to your fact situation. Because many of the cases are decided on factual circumstances. I think that what has emerged is that the cause, if you will, for the need can really be divided into two main areas. One is sickness or ill health, which can arise either during the marriage or after the marriage, and the effect that has on a spouse's income earning potential and ability to be self-supporting. And secondly, the economic pattern of dependency which is generated through the marriage, and especially in marriages of long duration, where the parties have held traditional roles during the marriage. So that these are really the two main areas where the cases seem to fall. The argument has been made as well that, getting back to the threshold argument, that this issue of causal connection originated, for our purposes, in the trilogy, and most specifically, perhaps, in the reasons of Madam Justice Wilson in the Pellich case. And in the trilogy, the facts were such that there was a variation of a prior settlement. The real question that I think we've all been grappling with over the last 18 months is whether one can extend that principle of causal connection, or the requirement of causal connection, to support applications at first instance, where there is no prior settlement, where there is no prior court order, where there is no prior settlement agreement by the parties. Can one argue on an interim stage, subsequently on a permanent stage, whether there is a causal connection requirement? And does a spouse seeking support have to, at at an originating application at first instance be required to prove a causal connection, therefore departing from the traditional means and needs test that has been adopted. Now, one of the arguments, and I'm not going to take you through all the cases dealing with sickness because they're clearly set out, and I would say the vast majority of cases deal with circumstances where one of the parties becomes ill, and it's an illness which either occurs during the marriage and is diagnosed afterwards or occurs afterwards. And if there is any trend developing from the cases dealing with illness or sickness, it seems to center on when the misfortune occurred, whether it was a future misfortune or whether it was a misfortune that arose during the marriage. And the further away you get from the termination date of the marriage, the less likely you are to be able to prove that your need is somehow causally connected to the marriage. In terms of the threshold argument, whether causal connection applies to support applications at first instance under either the Family Law Act of Ontario or the Divorce Act, arguments have been made appropriately that the causal connection test is not expressly stated in either act and therefore shouldn't apply, that the Divorce Act 1985 came into existence prior to the trilogy and therefore should not be read with the strictures that are set out in the trilogy, that the trilogy cases dealt with the old Family Law Act, or the old Divorce Act, and therefore has no application to the new Divorce Act. With respect to the argument of whether the principle of causal connection applies to cases under the Family Law Act, and I won't differentiate at this point in time with respect to interim and permanent support applications, because interim support is dealt with later in the program, and I would refer you directly to Nancy Mossip's excellent paper, which was written for the Institute a few weeks ago. My paper also deals with cases involving interim support applications. I'll touch upon interim support applications if I have a couple of minutes, but essentially I'm lumping them together and I'm not making any distinction at this point in time. But I draw your attention, I think, to a few cases which deal with causal connection, the causal connection argument under the Family Law Act. And excuse me, I have found 8 cases that deal with applications under the Family Law Act, and they are the early cases of Nadeau and Keefe, which are decisions of Judge Wright, which are both interim applications. The Stojanowski decision, the Fisher decision, Wetlaufer, the interim application in Lobelio, which is Judge Morrissey's decision out in Brampton, Judge King's decision in Medill, which is probably the most extensive review of the application of causal connection, and I highly recommend your reading that judgment in its entirety. And lastly, the Perrin decision. It's interesting to note that in these 8 cases, 4 cases applied the causal connection prerequisite, and the 4 cases said that there was no application under the Family Law Act. In Judge King's decision, she stated quite accurately that there was no causal connection prerequisite expressed in the Family Law Act, that there was an obligation, a legislated obligation on both spouses to support not only themselves but to support the other, and that the rationale that the support obligation should fall upon the state in cases where causal connection wasn't proved, and which was espoused in the reasons of Madam Justice Wilson, simply didn't apply to applications under the Family Law Act. This decision differed from the other Ontario Provincial Court decision in Stojanowski, wherein Judge Weisman held that the sections dealing with support under the Family Law Act reflected the same shift in focus from apportionment of blame to an assessment of what was reasonable based on the needs and means of the parties, as did the Divorce Act, and that applications under the Family Law Act could apply causal connection equally as applications under the Divorce Act. I think it's interesting to note Judge Wright's reasons in both Nadeau and Keefe. They were 2 of the earliest decisions, and I commend Judge Wright for dealing with the issue before many other judges had the opportunity to deal with the issue and comment on it. He made an interesting comment in his reasons, which I find to be quite applicable. He states, "Today, counsel for the father tells me that new winds are blowing again, and that from a philosophical point of view, there seems to be no reason why the tests applied by the Supreme Court of Canada should not apply on an interim basis. I can only respond with Holmes' famous comment that the life of the law has not been logic, but has been experience. And while logic may dictate that these tests be applied on an interim basis, the fact is that those tests were formulated on variations relating to final orders, and I'm not convinced that they apply today." He also held that he wasn't convinced that the application of the causal connection prerequisite applied to cases under the Family Law Act. It's interesting to note as well that other judges have taken the view that the causal connection prerequisite doesn't apply to applications under the new Divorce Act. And I draw your specific attention to the Linton case of His Honor Judge Killeen. And he reasoned that the trilogy didn't apply to support applications in the Divorce Act because the Divorce Act preceded the Pellich, Caron, and Richardson cases, and therefore couldn't be interpreted within the provisions of the trilogy. He stated that some of the reasoning in the trilogy couldn't be ignored because of the similarities to some of the concepts expressed in the support provisions of the Divorce Act, but that these were cases, the trilogy were simply cases dealing with other issues under different fact circumstances. The Manitoba Queen's Bench in the case of Hunkin and Hunkin also questioned whether the trilogy applied to applications under our new Divorce Act, since the trilogy cases arose under the old Divorce Act. So I think what you're seeing, and I think what I would like to leave you with is threshold arguments being made, and being made successfully and unsuccessfully, by the way, that the causal connection prerequisite doesn't apply to the new Divorce Act and doesn't apply to the Family Law Act. And it may be that the only way that clarity is going to be truly achieved is through a change of legislation or clarity through a higher court decision, most preferably a decision of the Supreme Court of Canada with respect to whether or not the issue truly applies. But one should not simply readily assume that it does apply. Now, I'm running out of time, and I've been very general, and there are a lot of things that I haven't said that I would have liked to have said, but there's going to be a very interesting debate between one of the main protagonists of the causal connection movement, if you will, J. McLeod, and Tom Bastedo, from an antagonist point of view. And I would like to leave perhaps that kind of opinionated argument to them, which I think is going to be very insightful and very interesting. I think in terms of an overview, I think what I can say is that there appears to be some emerging common threads in the cases. It's still extremely unclear. And if you have a case where causal connection might apply, either for or against, you should plead it, and you should plead it at the very first opportunity, at an interim stage. Master Clarke in Toronto has been one of the main antagonists against the application of the causal connection principle to interim applications. And notwithstanding Mr. Justice Rosenberg's reasons in the Smith case, where he said that causal connection had equal application to interim support applications as it did in permanent applications, Master Clarke simply has taken the view that it would be improper for him to decide the merits of the case on an interim application without a full trial of all of the issues. And I refer you specifically to two recent cases which are in my materials. One is Domenico and the other is Bailey, wherein he says that he won't apply it unless it's so clear and so obvious that the spouse claiming support isn't going to be entitled to it eventually upon the permanent application. So with those comments, I see George breathing heavily and coughing in my ear. I hope you enjoy the day, and I hope you come away with some better understanding, or at least if it's foggier, some indication of where we might be going. Thank you.
Thank you very much, Paul. I'd now like to introduce our second speaker, Professor Carole Rogerson, who's a professor of law at the University of Toronto Faculty of Law. Professor Rogerson is a graduate of the University of Toronto and obtained her LLM at Harvard. She's an active academic, both as a teacher and a writer.
And a jogger.
As a jogger. Well known for her broad interdisciplinary approach to the teaching of family law, and if you want any proof of that, you should acquire her teaching materials, which I think would be a valuable addition to any lawyer's library. She's also active in a large number of organizations. She's an associate editor for the DLRs. She's on the LEAF Family Law Study Group and on the research board of the Child, Youth, and Family Policy Research Center. She's also been very active. She's a teacher who's very active in continuing legal education. She's on our Family Law Advisory Committee, the committee that recommends the family law programs we should offer here at the Law Society. And she's also a member of the faculty for the Federation of Law Societies annual family law program, actually biannual at the moment. And so at this point, I would simply turn the program over to Carole.
Thank you. Let me begin by saying something about the paper. It doesn't say so on the front of the paper, but it's very much a first draft. It's very much a work in progress. If you read it, you will notice a lot of typos, which are the most obvious evidence that it's a work in progress. One glaring typo is found on page 40. There is a line somewhere on that page that talks about the dominant spouse. That makes no sense at all. And the actual word should be claimant spouse. And in fact, the claimant spouse will usually be the less dominant spouse. So that was the most obvious typo that I found on rereading. It's also very much a work in progress, not only in terms of the quality of the typing, but also in terms of the ideas. This paper is my first attempt to set down on paper some of my way of thinking through what I'm finding to be a very difficult and confusing area. And I don't expect you to take it as some sort of oracle of academic wisdom. There are ideas out there to help us all think about the causal connection test. My starting point is that I have found this whole, the debate that's been generated about the causal connection test very confusing and in fact very disorienting. And I've had a hard time figuring out where I actually stand in terms of the various positions people are taking. On the one hand, I'm very critical of many of the applications of the test and the results that I'm seeing in the case law. On the other hand, I am someone who I guess starts out with a general acceptance of a vague notion, a general philosophy of causal connection as being a very sensible explanation of what spousal support law is about. And here I'm distinguishing between causal connection as a concept and as a general philosophy. And I'm distinguishing that from causal connection as a very specific threshold prerequisite for support. But in terms of a general philosophy, I guess I would say that I am someone who thinks that that's a sensible way of thinking about spousal support. And hence I found myself in the rather odd position both of being critical of the current causal connection test, yet also not in complete agreement with a lot of the other critics who are, I think, in criticism putting forward views of spousal support and philosophies of spousal support with which I don't completely agree. So my paper is really an attempt to try to bring a little bit of clarity into this whole debate and trying to, find where I am in it by creating a kind of map of the terrain, a map of the different kinds of arguments that can be made and the different ways of thinking about what's at stake here. And in the end, I also give you some thoughts on where I end up and where I seem to be placed on this map. But even if you don't find yourself on the same place on the map as I do at the end of the day, I hope that the map will be useful to you in the sense that it clarifies the ways we have of arguing about this and clarify some of the different positions that people might take. Let me say a little bit about causal connection generally and the nature of the debate that has been generated. I think that the debate about causal connection is really a debate about the meaning of spousal support law in general. It's not a debate about some specific discrete test. I think what it raises is the basic issue of what is spousal support about. And I think furthermore, any debate about what spousal support is about is ultimately a debate about the meaning of marriage in modern society and the obligations which flow from it. So we are into a very difficult debate here, the meaning of spousal support and the meaning of marriage. And I think it's no surprise to anyone that there's a lot of confusion on these issues and there are no easy answers. And I think despite the fact that we have basically been dealing with these issues for 20 years, both in a broad social sense and also in terms of specific legal reforms of spousal support law, we have not yet really faced directly the issue of what is marriage about and what does that mean about spousal support. I think if you look at the current legislation that we have, that's the byproduct of these 20 years of legal reform, you will see that although attempts have been made to create a modern law of spousal support, no actual decision has been made on what our philosophy of spousal support is. If you look at our current legislation, I think no one has really bitten the bullet and said, this is our philosophy. The current legislation gives lists of several criteria, several objectives, and no one philosophy is clear. And I think what has been happening to date in the area of spousal support is that we have this legislation with a whole bunch of criteria, and it's allowed people to think that we're all talking about the same thing. But in fact, different people, different judges in particular, interpreting the legislation, interpret it in different ways. But everyone's thought that we're all doing the same thing because we're operating under the same legislation. I think we haven't all been doing the same thing, and people have been basically adopting different approaches under the umbrella of existing legislation. What I think the causal connection test has done is it has, for the first time, really made us confront what is our philosophy of spousal support. And it's kind of taken away the mask of the legislation, something that's led us believe we're all doing the same thing. And this new debate has brought out the fact that we aren't all doing the same thing and we don't all think the same thing. And I think what we now have to do is figure out, what do we want our law of spousal support to be? And the legislation is not clear, and we have some incredibly difficult value judgments to make. Now, what I have done in the paper is to outline 3 different visions of what spousal support is about. 3 different visions of how one could argue about spousal support and its purposes. And I want to outline those, and I think then once you've got an idea of the different possibilities for spousal support, you can start to look at causal connection and figure out where it fits in. Now, these 3 models that I'm going to talk about each have some rooting in the current legislation. You can look at the current list of objectives and find signals that reflect each of these 3 models. But I am also going to play academic, which is basically not playing, that's what I am. And although these are rooted in the current legislation, I'm going to engage in a bit of an exercise of caricature or abstraction, and I'm going to make them purer models of support than they really are in the legislation, where I think they all work together. But I think it's important for analytical purposes to get a sense of the essence of these 3 different ways of thinking about spousal support in order to determine basically which one you tend more towards. So it really is in part an academic exercise that I'm engaged in. The first model that I isolate in the paper is what I call an income security model of spousal support. Spousal support as a scheme of income security. And I think the legislative reflections of this model are found in the needs and means wording that is part of our current legislation. And the basic idea about spousal support that is the basis of the income security model is the idea that spousal support is there to provide income security to a former spouse, to meet the economic needs of a former spouse to the extent that he or she is not able to do so at the end of the marriage. Under this model in its pure form, you don't ask any questions about where the needs came from. If at the end of the marriage there's economic need and the spouse can't meet those needs, spousal support pays. And I think on the fullest implementation of this vision of spousal support, there would be a guarantee of a reasonable standard of living, or maybe the marital standard of living, in every case. So the basic idea here is basically spousal support as a private social security scheme. This model, it seems to me, comes closest to the traditional model of support that we had in the past. It's gotten rid of the ideas of fault, but it's still very much rooted in the idea of support as an income security scheme. And I think if you're thinking of an analogy from other areas of law, the analogy would be contract law or promise. Marriage involves a promise of support, a promise of income security, and that is ultimately the source of the obligation. Now, I think on the fullest version of spousal support as income security, in a case where a spouse is ill at the end of a marriage and will not be able to meet his or her needs, may not be able to work at all, the fullest implementation of this would say permanent support. You made a promise, a promise of income security, and that's to be fulfilled at the end of the marriage. Now that's the model in its fullest form. The second model of spousal support that I isolate is what I call the compensatory model of spousal support. And the language in the legislation which reflects this understanding of spousal support is the language of economic advantages and disadvantages flowing from the marriage. And both pieces of legislation have language similar to that. I think the other language that would reflect this is the language which directs judicial attention to the division of functions which took place within the marriage. The basic idea in this model, this vision of support, is that support is there to compensate someone, a former spouse, for the economic consequences of the marriage. This model of support is rooted in what happened during the marriage and in the economic relationship that developed between the spouses during the marriage. In the past, I would have called this causal connection, but as I indicate in my paper, I'm nervous to call it causal connection because that associates it immediately with the pattern of case law that we've seen, and I don't think the two are necessarily congruent. So I've chosen instead the term compensatory support. Now, under this model, you can imagine different kinds of compensation. You can imagine compensation for loss of opportunity. You can imagine compensation for detrimental reliance. You can imagine compensation for contributions to the relationship, a kind of unjust enrichment model, in addition to a kind of tort-based model, which is what a loss of opportunity model is. Now, in contrast to the first model of support that I outlined, the income security model, where the basic argument that you come to court with is, I have need, and therefore I should get support because you have means. The argument you come to court with as a basic justification for support under the compensatory model is, I'm claiming support because of what went on in this relationship, and my claim springs from what went on in the relationship. The third model of support, and it's one that Tom Bastedo outlines very well in his paper, is the clean break model of support. The language in the legislation, which seems to be the reflection and inspiration for this model of support, is the language of promoting self-sufficiency. Now, on the extreme version of this model, the purest model, the primary goal of spousal support would be to cut the ties between the spouses as quickly as possible. And that, per se, is what is the primary mode of driving spousal support. Support should be at best transitional and allow an adjustment period before spouses are set on their own economic courses. On the extreme implementation of this model, support law would not look at actual outcomes. It wouldn't look at whether someone was actually economically self-sufficient at the end of the marriage. It wouldn't ask whether all of the economic consequences of the marriage had actually been compensated. It would simply ask how much time has passed, and has enough time passed so that, we think the tie should be cut. So there you have three different ways of thinking about what spousal support should be doing. Spousal support as income security, spousal support as compensation, and spousal support as clean break. And now we have, coming on the scene, this new causal connection test that Paul has talked about, a test which limits support to situations where the need has been caused by the marriage. Knowing what we know, what I've just told you about these general ways of thinking about spousal support, how does one react to and analyze this new test? I think there are two possible responses. Actually, I think there are three possible responses. One response is that everything is just fine with the new causal connection test, and we don't have to think about it anymore. I'm actually eliminating that as a response. Because I think there are enormous problems with it. And so when I talk about two possible responses, I'm talking about two possible critical responses, two ways of expressing concern with what is going on in the current case law. One response, and I think this response is the response you make if you are rooted in the first vision of support law that I presented, the idea of support law as a guarantee of income security. If that's where you're placed on the map, your response to causal connection is going to be that this test has just got it wrong completely. Whoever thought there was any idea that support had to be rooted in what went on in the relationship? The legislation talks about needs and means. It's really an income security scheme. If you come to court and present need, then you get support. And if that's where you are on the map, you have enormous difficulty with causal connection conceptually as well in all of its applications. And your argument is that it's just an irrelevant consideration and it's illegitimate to bring it in. Another critical response, and this is the response you take if basically on the map you're rooted in the second vision of spousal support as compensatory. Your critical response here is that in a general philosophical way, causal connection makes some sense. It explains where we think the spousal support obligation comes from. It comes from what went on in the relationship. But when we look at the current test and the way it's being applied, it is in fact not adequately compensating people for what went on in the relationship. It's looking at the relationship through a distorted lens, and it's ignoring economic consequences of the relationship rather than finding them. And my way of presenting this criticism is that the causal connection test is really a Model 3, a self-sufficiency clean break test, masquerading as a Model 2 test, a compensatory causal connection model. Now, I think it's important in terms of your own thinking about this to figure out, if you're critical of causal connection, which of these two positions best expresses where you're coming from. And in doing that, I think you end up articulating a basic vision of spousal support. As you can tell from my paper, I fall into the second critical response. I think my criticism of causal connection is that philosophically, I think spousal support should be about compensation and compensating for what went on in the relationship, but I think that the test has gotten it wrong. It's being severely misapplied. And I guess I take that point of view because I find it very difficult to argue that in the modern world, where we have recognized the terminability of marriage, I find it difficult to say that marriage per se involves a guarantee of economic security, and in some cases, a long-term guarantee of economic security, simply because of the fact of marriage. And for me, the second model of spousal support, the compensatory model, is the appropriate compromise between it recognizes both the terminability of marriage in modern society, and but also the fact that marriage has real life economic consequences for people, and you have to deal with that. Now, I know there's enormous debate on that, and I know that not everyone is going to agree with me on that. What I then go on to do in the paper is to point out the ways in which, even though I think that a compensatory model of support law is right, and hence causal connection makes some general sense, the ways in which I see the current test distorting the appropriate and objectives of spousal support and missing a lot of causal connections and economic consequences which flow from marriage. And let me just briefly outline 3 ways in which I think the current test is missing cases where compensation is due. And I think I should add that even those who take a different critical stance from me and say that it's really needs and means and income security that spousal support is all about will likely agree with these criticisms. They may go further, but I think they would agree with me that spousal support should at the least be dealing with the things that I think it should be dealing with. One point that I think is very important to make is that I think in almost every marriage there is some economic interrelationship that would be the basis for at least limited term support. And hence I find the idea of causal connection as a threshold test that in many cases would deny any support at all quite bizarre. Because I think in most families there is some economic interconnection if you're sharing a standard of living. And there is at the very least some reliance on that. And you're going to need, when the marriage breaks down, some time to reorganize your life. You've organized your life on a current state of economic affairs. And at the very least, you need a transition period. And I would say that's true in all of the illness cases as well. You can't just cut someone off. The relationship has put them in an economic position where they've had a source of support, and they need, everyone can claim at the very least, some support for a limited period. And I think that that springs from the relationship and the fact that you've created a joint standard of living while you were married. So that's at the very least, and I think that that really deals with the strict threshold entitlement problem that's being created by causal connection. My second point is that although I believe in a compensatory model of spousal support, I think that in fact the losses and contributions that it tries to compensate for are very difficult to calculate. And that one of the ways in which the current causal connection test has gone astray is by trying to very strictly quantify these things. I think what it misses is all of the subtle ways in which parties do create economic interrelationships and the very complex economic consequences which flow from having been involved in an economic partnership. And I would think in particular that the longer the relationship, the harder and harder it becomes to actually do what current practitioners of the causal connection test say we should do, which is to quantify the losses and figure out where someone would have been but for the marriage. That is an exercise in fantasy the longer the marriage has gone on. And I think that what we have to rely upon, even if our basic philosophy of spousal support is compensatory, is some basic rules of thumb and presumptions. And for me, the legislation, as it in the current list of criteria gives some very good rules of thumb and proxies and presumptions. In particular, I think length of marriage is a factor that is very relevant, and the standard of living during the marriage. And what I would say is that the longer the marriage, the more likely that there are economic interrelationships, both in terms of losses and contributions. The longer that relationship goes on, the harder it is to quantify. And the best we can do at the end of a long marriage is say that people should end up in roughly similar economic positions. I think we have to concentrate on standard of living after marriage breakdown as a kind of proxy for this calculation of losses and contributions. And the longer the marriage, I think, the more sense it makes to rely upon the standard of living achieved during the marriage. The third point I would make in terms of a compensatory model of spousal support, and where I think the current causal connection test is going wrong, is in terms of what I call middle-length marriages, where I think a common fact situation that's arising in the cases now is one where marriages are breaking down and the wives leaving the marriages are in their mid-30s and late 40s. They're still relatively young. I mean, there's a fairly long working career ahead of them. But they have not made major investments in any sort of job during the course of the marriage. They've had at best a limited connection to the job force, to the labor force, because of taking primary responsibility for the family. I think the current tendency in the case law is to look at those cases where a relatively young spouse, not a 50 or 60-year-old woman, but a relatively young spouse is leaving a marriage with some job skills, can move into the labor force and get a minimum wage job, and the courts are looking there, I think, through the lens of this new causal connection test, and they're saying there's no causal connection there. She worked before, she can still work, the marriage has had no impact on her, no causal connection. To me, that's a misapplication of the test, and I think it ignores the long-lasting loss that accrues to that person from missing out on investing in career in her 20s and 30s. I think she is never going to be able to regain what she lost. And I think a properly applied compensatory model of spousal support says, look at that, and we have to take very seriously those losses. We have to see them. Under the current causal connection test, I think those losses are being ignored. And the courts are saying there's no causal connection. I just think that's wrong. There's an obvious causal connection there. And when courts say there's no causal connection, they're really applying a self-sufficiency test. Now, the last point I'd like to make is with regard to illness. And I think it's with regard to the cases of illness that you will get very different results depending upon which of the critical stances that I've outlined that you take. If you really view spousal support as a scheme of income security, I think your response in cases of chronic illness is going to be that there should be a fairly lengthy support obligation imposed on the former spouse by virtue of the fact of marriage. If you adopt the model that I adopt, which is a compensatory model of support, you don't reach that result in all cases. And I think the end result is that in some cases of illness, there is a limited term support obligation rather than a long-term support obligation. A support obligation that compensates, that gives an adjustment period to deal with the end of the provision of support, but not a long-term obligation. And I think under a compensatory model, what you would look at is the illness in the overall context of the relationship. And you would say, if prior to the illness there was a relationship of economic interdependency and economic consequences flowed from that, then support would be forthcoming to compensate for that prior arrangement which had been created. But on the other hand, if the relationship had been such that the parties really were functioning basically as economic individuals, and then one spouse gets hit with an illness, on the compensatory model, the result would be that there would be no long-term support obligation. And so where I come out is that when I look at a case like Wilms or a case like Winterly, where you have very short marriages, no division of responsibilities in the marriage so that one spouse was removed from the labor force, say, to care for children. You have both spouses working, one becomes ill. I say in those cases that that spouse is not in a very much different position than a single person. And what the entitlement there should be some support for an adjustment period, but not permanent support because of the fact of marriage. And I think if you take the first approach to spousal support, you might come up with a different result, and you would say that there should be a long-term obligation there because by virtue of the fact of marriage, and that's what we think marriage is in our society. So I think it's the illness cases where you're really going to find a difference in approach. I think in terms of the non-illness cases, the typical case of where there has been some division of responsibilities in the marriage, one spouse more responsible for child care than the other, whichever critical stance you take to causal connection, you're going to end up in the same position, which says adequate compensation is not being given in those cases because we really aren't recognizing the economic consequences of the marriage. But the illness cases is where there will be a difference, and I think there's room for a lot of debate there. And in the end, I think it does come down to your view of what does marriage entail. I mean, does it entail a promise to look after someone? Is that still very much part of our notion of marriage in our current society? As a final point, let me just say, and it's kind of my overall assessment of the debate, I think in the end that causal connection has been blown way out of proportion, and it's been crystallized into some sort of very special threshold test before you can ever get into court and argue about support law. I actually think that causal connection is already embedded in the legislation to a large extent. And it's embedded in the legislation in the objectives that we have written down and the criteria that courts are directed to look at, i.e. length of marriage, division of responsibilities within the marriage, and who's responsible for kids after the marriage. All of those are causal connection to me. They're already in the legislation, and I think the legislation was basically getting it right. And there's no need to create this threshold test of causal connection because you're into it when you're in the legislation already. So that's my final reading on causal connection, wherever you end up on the map. Thank you.
Thank you very much, Carole, for providing obviously a very clear and excellent context for what we're now going to do for the rest of the day, which is to have you attempt to use those arguments following this debate in specific fact situations. While the panel is taking its seat, other than mine, if I might just say one thing about the workshops. When you go to the workshops, you're going to be asked to deal with a couple of fact situations, and you're going to play the role of one or other, a lawyer for one or other of the parties, or you're going to be one of the judges. In order for the purpose of the workshop is to have you use these arguments, use the theories and the grounds that lie behind the theories in a specific fact situation. It'll only work if you take it very seriously, we think, and actually force yourselves to a decision. We must get a result from you in the fact situations that you're going to deal with, and then we will this afternoon show you the different results from one workshop to another dealing with the same fact situations. But it is important that you use the time to actually get yourselves to a decision and to work with the arguments themselves. And you will go straight from this next session to get your coffee and off to the workshops, if you don't mind, perhaps with one other short break. Although we've identified two chairs for this panel, in fact, Judge King will be playing more the role of participant rather than chair. So I will simply introduce Phil Epstein, who is probably well known to all of you. He's a partner in the firm of Epstein and Cole, the head of section of the family law course here at the Bar Admission course, and perhaps the most active continuing legal educator in the field of family law in the province. So I'll simply turn it over to Phil.
Thank you, George. We're very privileged, I think, today to have these three panelists with us. Judge King is well known to you, a judge of the Provincial Court Family Division in Toronto, a former family law lawyer in Toronto, and the author of one of the more important decisions in this area. To my immediate right, Tom Bastedo, a bencher of the Law Society of Upper Canada, a chairman of the Legal Aid Committee, a very senior practitioner in family law, and also well known to you. The person probably least known to you is Professor J. McLeod, who has decided to embark upon a venture of writing about this area, and I think to some degree helps bring us all together today. Professor McLeod is a professor at the University of Western Ontario, which is a law school in London, and also practices family law and occasionally appears before the courts. It is important that we try to have an intellectual debate about some of these areas and keep the debate on a high level. So in order to do that, we're going to start off by allowing Professor McLeod to talk for approximately 7.5 minutes, and then Tom Bastedo will respond, and then Lynn will pose some questions, and then we'll get going. Jay?
From Phil Epstein and the powers that be, I have 7.5 minutes to state my views on causal connection. To a large number of you, that's 7.5 minutes of wasted time. From what I understand from speaking to people and from what I've read, most of you are of the opinion I've said quite enough on causal connection. The truth be known, I agree. I don't really want to say anything more on it. When I sat at this seat about a year ago and said something on it, those of you who were here will remember I got booed and hissed out of the building, and they praised Judge Killeen, which really upset me coming from the same county. However, to set the record straight, I think causal connection provides a rational means of awarding or withholding continued financial assistance to a spouse after the relationship is broken down. That's all I think it does. You know, so as not to upset Carole Rogerson, I agree with just about everything she said, which could get you into trouble now more than me, I think. The positions neatly stated by Rosie Abella in her opening address to Family Law in Canada, New Dimensions, which is the National Advisory Committee on the Status of Women, 1985 publication out of Ottawa, and I apologize for taking this out of context. I just don't have enough time in 7.5 minutes to say it all. She says, quote, "To the extent that the spouse could claim that the marriage damaged his or her economic well-being, there would be rehabilitative support, period. If the family relationship resulted in no economic dependency, then the breakdown of the marriage would result in no economic consequences and no support." That's, as I see it, all that the causal connection doctrine is about. Most of the problems that have come about, I think, are misconceptions, misapprehensions, and confusion. It is a lot of smoke in many of these cases. Much of the confusion, I think, comes out of nobody's quite sure what we're talking about when we use the words causal connection. If you watched the Academy Awards last night, Walter Matthau said words with C's in them are funny. I don't think much of us found funny in causal connection over the past year and a half. Looking at the definition, I don't think causal connection is an end in itself. It was never intended to be an end in itself by me, if I've had any part in what's happened. I view causal connection as an element or an aspect of compensatory analysis to support. Purpose of support is to ensure that no person suffers unreasonable economic loss by virtue of getting married. If the marriage has had no economic impact on you, then I don't see why there should be any support out of the marriage. On the other hand, if as a result of the marriage you are less able to function as an independent economic entity than you would have been without the marriage, there is a causal connection and support should be awarded. What I'd like to do in the remaining 6 minutes of my 7.5 minutes is to address some of the concerns and criticisms that have been made to me and see if I can deal with them in any realistic fashion. For any of you who find cases offensive and think you'd like to write on them, let me encourage you to write annotations to these things. Send them to me. If you really think that I won't publish them, you're wrong. But if you do think that, send them to the publisher. They'll publish them and not tell me. Send them in. The only one who's taken me up on it is Carole Curtis's office, and you can tell them, Carole, we did publish it. So going back to the criticisms. First one that comes out regularly is the causal connection doctrine is going to lead to the weaker economic spouse, generally the wife, being thrown out on her own at the first available date. As Carole Rogerson said, that's to confuse causal connection with clean break. I don't think they're the same thing at all. If the marriage has had an adverse economic impact on the spouse, then the spouse should get support. If you can say we can quantify the time, 3 years, and then we've satisfied the problem, you get 3 years support. I don't think that's realistic or possible in very many cases. The most you can say is probably in about 3 years on the facts, you should be self-sufficient. You can make an award to that effect. But if at the end of that time that person's not self-sufficient, they should be able to come back and show that they're not self-sufficient. The assumption was wrong and the support should continue. You can't just say when you get a job, then support comes to an end, because the marriage cost you your early entrance into the market. It's harder to get a job today than it might have been 15 years ago when you were looking. Somehow you've got to make the marriage pay for that. Nor can you say as soon as you get a job, support should come to an end, because the return to you from that job may not be enough to make up for what the marriage has cost you. If without the marriage you'd have been in a workforce making $35,000 a year, the fact that you can now go out there and get a job at $15,000 or $18,000 doesn't compensate you. Your spouse should be expected to top up the award. So first thing, the confusion about throwing people out confuses, I think, clean break with causal connection or compensation, and they're not the same thing. Second major misapprehension or criticism that comes is that causal connection will lead to wives having lower standards of living than husband. That's one that comes up quite regularly. Judge Killeen in the Linton and Linton decision, and in his mock award a couple weeks ago, Tom Bastedo in the paper that you've got in front of you, seemed to suggest to me that causal connection is a major contributor to the feminization of poverty. Now, whether you use the phrase or not, if you've looked at that blue material from Diane Pask's group, I think it's very clear that women in the workforce earn less than men in the workforce. The marriage becomes, in a sense, a non-issue to that. If these two people had never gotten married, she probably still would use or earn less money than he would. What it comes down to is who has responsibility for the systemic gender-based discrimination in society. And I say it's not your spouse, it's not the husband. Support is a personal and private right or responsibility that's there to deal with personal and private organizational inequities. If the parties have arranged their lives so that there's a private economic discrimination, then let the marriage pay for it and support be awarded. If society has done it, then let society pay for it. Don't visit the sins of society on your spouse. Make me pay for those things I've caused, but don't make me pay for those things that I've really had no hand in. To those people who say support is aimed at redressing gender-based inequality, then 2 points I make. One, we disagree on a fundamental point of policy, and you can't argue about it. When you disagree, it's step one. It's a political decision. Someone's got to make it. And until somebody else makes it, I'd suggest that the Supreme Court of Canada has said it's not intended to remedy that type of discrimination. I got a whole bunch more, but now I have 30 seconds left to deal with them in. And since I can't do it, let me say that if you look at the legislation, you don't find the words causal connection in the statutory crayon box. Everybody who says that is absolutely right. However, nobody said causal connection was an end in itself. I say it's an aspect of remedying economic disadvantage. Look in the objective section of the statute, section 15.7 of the Divorce Act, section 33.8 of FLA, and that's what they talk about. They talk about redressing economic imbalance. The purpose of the legislation is the objective of the legislation. You aim to that objective. Proper purposes doctrine. Don't use a power intended for one purpose for something else. I say it's already there. If you don't think so, I think Carole Rogerson may have a point that it's ambiguous. Somebody has got to step in and give a purpose. Look at the Corkum decision by Judge Meisner, who's no lover of this area. He goes through it and says, when you do it, it's there, that's it. I stop in mid-sentence. Thank you so much.
Thank you for that 78 RPM delivery. I'm trying to move to at least 45. Tom Bastedo, some response.
Thank you. Lawyers feel very uncomfortable talking about values because our job really is to articulate the wishes of our clients. But today I'm going to talk about values, and I wish in the future when you talk to me about our clients, you'll forget about what I said today. But I really feel today is a time to talk about values, and what I'd like to do is ask 4 questions rhetorically, and then I wish to make 4 brief points, and then I think the real differences between Jay and me will come out in our discussion. And I've spent some time in these questions because I think that the essence of our inquiry ought to be starting at the end rather than the beginning, because I agree with Professor Rogerson in her textual analysis of the statutes, really, which says that we can make these words mean what we want them to make. So my first question is, are we satisfied that the actual results which have come out of the court system in the last several years are acceptable in a societal and political sense in accord with a philosophical value structure which is wide and in fact majority support? And my answer to that question is no. My second question is, are we convinced that these results are a necessary and ineluctable product in a textual legal sense of our current legislation and higher court pronouncements? And I say the answer is no. Third, in examining the so-called causal connection type of analysis favored by some courts, are we satisfied that the causal connection has been competently examined having regard to the structure of interdependence in marriage and the empirical evidence of what actually occurs in an economic sense in a marriage partnership relationship? And again, I say the answer is no. Now, we all agree that we must make some choices. And therefore, I ask lastly, have we the freedom to do so within the legislative boundaries by judicial legitimate interpretation having regard to the dictates of the higher courts? And I say we have. In summary, my position is that the results which are coming out of the court system, particularly since the Delage decision in 1983, are not acceptable in our society, and that these results are not preordained either by the interpretation which the courts have put on the legislation or by the plain reading of the legislation itself. Now, having set out those questions, let me put forward 4 brief points which I think go to the root of this problem. First of all, there is nothing new in causal connection. Causal connection surfaced really in the 1968 Divorce Act, and I think it is obvious and trite to say that it's obvious and trite to say that there is a causal connection in a marriage. Obviously, there is a causal connection in a marriage. Obviously, it's been there forever, and it will continue to be there. The mere advancement of the words, however, of causal connection have attracted a mystical patina towards this debate, which in my view is not justified. As I say, the Divorce Act can give rise to many theories, and the problem which we have in these words causal connection is, in my second point, is being used to promote a clean break theory. I don't care what you call it, that is the result. And if you look in my paper, you don't have to look to right this moment, but if you look at my paper, page 4, you will see the contrast between the English Matrimonial Causes Act of 1973 as amended in 1985 and our current legislation. That English statute clearly says maintenance should be terminated as soon after the divorce decree as the court considered just and reasonable. That is a clear legislative dictate which is not present in our legislation. The legislative policy by section 15.7 does not, I repeat, does not say that there ought to be a clean break between spouses at the end of the marriage. It does say, as Judge Killeen said in his mock judgment the other day, that there ought to be a judicial blend of the various factors which are set out in the Divorce Act, and those factors are not to be viewed as preeminent one over the other. And surely, if we look at the statute, either the Family Law Act or the Divorce Act, we must come to the conclusion that the objective of support really is what Professor Rogerson has said, and there has to be a real rehabilitative function here which has to last for a longer period of time. Now, the third point I wish to make is if we agree there is a causal connection, which I say that we must and which I say is obvious, the problem is that there is a fundamental lack of knowledge and a fundamental lack of understanding of the economics of a marriage relationship. Now, this doesn't go to a Judeo-Christian description of marriage. It simply goes to the preamble of the Family Law Act, which views marriage as a partnership and which recognizes that when two people live together, there have to be compromises. And in my view, the ordinary situation means that one person is going to compromise more than the other. I'm not talking here about the unusual case, the atypical case where two actuaries, marrying male and female, live and get married together and each project their own careers. We're talking about the ordinary situation, not that situation in which someone becomes a paraplegic 3 days before the separation. Now, if you look at page 9 of my paper, and I'd ask you to look at that for a moment, and I won't read what the summary is in page 9 because I've only got one more minute, but I will say that there are a number of empirical studies which clearly set out the economic results of a marriage relationship. And these points, these are empirical, factual data gathered by sociologists and economists. They are set out here, and the fact is they are not being recognized by the court, and they ineluctably result in an interdependence. The last point I wish to make is the failure of the courts to recognize the plain interpretation, the plain wording of the statute, the failure to apply a causal connection in terms of economic and sociological theory has resulted in a number of silly decisions. And I agree with Carole Rogerson that these silly decisions, in my view, are centered mostly at the middle range type of marriage. And a good example of that, and I say this with all respect, is the MacDonald case in British Columbia, which is set out in my paper, which is an excellent example of what is happening in the courts today, where a man and woman were married for 15 years. The man's a lawyer, he's earning $150,000 a year. The woman put him through law school, goes back to work, and gets support for 2 years with 3 children. Now, this is just not acceptable, and it's time that the injustices which flow from what has been written about are rectified. Thank you.
Judge King.
I want to address something to Jay, and it goes back to, and I guess it goes back to Professor Rogerson's paper as well, and that is really getting back to the legislation, because I think it's all fine for us to sit here and talk about what we think spousal support should be, and in the best of all worlds what it ought to be. But right now we do have legislation, and that was put in with a lot of thought, and I think that there's a lot in the legislation that we can look at that directs us what we should, tells us what to do. Professor McLeod, in his paper on page 21, and it's just one sentence I'll quote to you, says, "The concept of continuing the support relationship past the termination of the social relationship in order to protect the public purse fails to reflect the expropriation of family functions by the state." And I gather that what he's saying is that really, at a certain point, the spouse isn't to support the other spouse, the state is. And I look at the Family Law Act, and I could also, I suppose, look at the Divorce Act, but just looking at the Family Law Act, I look at section 33(3) that says that a public agency can apply for support from the husband if they have to support the wife. In other words, they can get the money back. Section 35(4)(b) says that a separation agreement can be overturned if the wife ends up on public assistance. Section 32 says that a parent can go and claim support from an older child. Section 30 says that a spouse can claim support from another spouse if they don't have enough money. All of those sections, and there's others, seem to tell me, and I remember when the legislation first came out, and this was the clear idea of the legislation, it seems to tell me that the idea is that the family will take care of the family, not the state. And I really think that that's what the legislation says. I don't think the legislation says that the state will take care of wives if they can't take care of themselves. I think the legislation is a clear attempt to have the family take care of the family. As well, I look at statistics and reports. that indicate that the state has no intention of taking care of impoverished wives or mothers. It has no intention whatsoever of doing this. And so if you look at the facts and you look at the legislation, it's clear to me, and it may be archaic, it may not be what we want, but it's clear to me that the idea is that the family, and in this case the spouse, is to take care of the impoverished spouse or the spouse who has need. Section 30 clearly indicates that to me. I think that what Professor McLeod is saying when he's saying, and he talked about the proper purposes doctrine, or when he's talking about it in his paper, is that he's passing the buck from the husband to the state. And I don't think the state has any intention of having that buck passed to it. And I really think that the purpose of the legislation is to have husbands or spouses support the spouse who's in need. And I'd ask Professor McLeod to reply to that.
If I could figure out the question, I would, so I'll try and figure out what we were saying. Page 21, make reference to the expropriation of family functions. What I'm setting up is the changing nature of the family in society. Historically, the family looked like Little House on the Prairie, that it took responsibility for medical help, educational help, economic futures, all the rest, and the state only stepped in when the family couldn't do it. If you translate that, that's not what happens today in society, I don't think. I think the state has taken over many of those functions. We have institutionalized religion, institutionalized education. I think now we're into a situation of more individuals coming together, interacting, and when the relationship breaks down, let the individuals go and compensate for what the individual interaction has caused. That's all it comes down to. And if the individual interaction has not caused this particular spouse, and in many cases we're talking wives, hasn't caused this wife's problem, then I don't see why the relationship should pay for it.
Well, I guess that's where I disagree. I think the legislation says that the spouse should pay for it and not the state.
I don't see anywhere in the legislation where it says for it. Section 30 isn't an entitlement section. Section 30 talks about who is entitled to apply for support. Not get an order, but who's entitled to apply.
No, I'm talking about the thrust of the legislation, and you seem to think the thrust is that the state will pick up the pieces, and I think the thrust is that the family will pick up the pieces.
I don't think the statute is that clear. Okay. I think it says whatever you want it to say, and it says whatever a judge says it says.
Tom.
That's the reality.
Let's bring this into sharper focus.
I think...
I like it the way it is, thank you.
I think one of the problems here is a statement which Professor McLeod makes on page 11 of his report, and this is a key matter which is dealt with by Professor Rogerson in her paper in somewhat more detail, and this is the mistaken assumption that the dissent by Mr. Justice Lammer in the Messier and Delage case really is summarized in the last paragraph of that decision, is transported into the majority judgment in the Peppiatt case. And Professor McLeod says, in the trilogy, the sentiments expressed by the minority in Messier versus Delage, and notice he uses the word arguably, form the majority and establish a new support model based on changed circumstances. Now, I think if you accept that statement, then you're in trouble, because in my view, the dissent in the Delage case does not transport into the majority in Peppiatt.
In order to bring this into sharper focus, let us take a scenario and see how the three of you would deal with the scenario. Because it seems to me that when you have a long marriage, let's suppose in this situation that we have a really long marriage, so it's 20 years. And let's suppose that at the time of marriage, the husband was a lawyer and had already graduated and was practicing law. He went into family law, so he's really doing well, and 20 years later, let us suppose that by some miracle, the husband is earning, Jay, $150,000 as a lawyer. The wife who married him after he was a lawyer was at the time a sales clerk in Holt Renfrew, earning $25,000. She has stayed full-time at that job, and some 20 years later is not earning significantly more because she earns most of her salary on commission. She works full-time at the job, so she was a sales clerk coming in. She's a sales clerk 20 years later. There are no children of the marriage, and the parties separate. Now, using your theory, or the theories that you have espoused, Professor McLeod, what is going to be the result in that case when the wife seeks support?
That's the same question that I got asked a year ago in the same chair, and everybody threw stuff at me. So at that point in time, I said no support. Today, I will say she can have support, so nobody boos. First question I'm going to take out of that, and I'm not trying to avoid it.
No, Jay,
is
could you
simply,
just answer the question so we can move along here? Right.
why did she remain a sales clerk? If she remained a sales clerk because she was there to assist her husband, support with the career, assume home care responsibilities because he's not there, then there's a causal connection that has prevented her from getting a further input into the workforce. An economic dependency is created.
No,
She's
she
entitled
liked
to
being a
support.
sales clerk.
That's all she
she
ever
li-
would have been. That's all she was. That's all she had aspirations of being as a sales clerk, and she never stopped being a sales clerk. No.
So she gets no support, notwithstanding the fact
No.
that they're...
She's not going to get, according to my analysis and what I read an economic dependency analysis to be, any continuing support. She should be entitled to some dislocation disadvantage support, which is what Carole Rogerson was talking about, the adjustment type of support. She's had an expectation of a lifestyle. She has not acted to her detriment, so there's no detrimental reliance in it. There is no causal link at all. But she's up there. You can't just go from speed there to speed there at one time. You've got to take into account the adjustment, so you give some limited term money to
But I take it
adjust.
that from what Carole Rogerson said, this lengthy marriage of 20 years, notwithstanding she's a sales clerk and he's a lawyer, would by its very nature create some economic interdependency.
But not of a long-term nature on the facts you gave me.
All
That
right.
she didn't do anything to her disadvantage. She didn't alter her life plans one iota.
No, but their
She
life
got-
plans got altered because the two of them used up their entire income in living.
Yes.
So they live at a lifestyle that requires very substantial monies that cannot possibly be emulated on her $25,000 or $30,000 per year.
No question.
And at her age now, having been a sales clerk for 20 years, she's not going to be able to improve her position. No question about that either. So, Tom, how do you say the results should work itself
Well,
out?
I'm going to give her some support for a fairly lengthy period of time, and the really important issue that this question raises is the question of proof. It is unfair for this lady to have to prove that she was in this situation because of certain facts. Now, if you look at the data, and it's really hard to discuss this question without having a knowledge of what has empirically been gathered over the last half dozen years since the early 1980s. But if you look at the data, you will see in a general sense that people like this woman have suffered economically because of their willingness to convenience themselves in the full sense of the word to the career and economic aspirations of the husband. Now, what I say is that ability of the lady to convenience herself to the thrust of the husband's career creates in and of itself an economic relationship, an interdependence, and a partnership. Now, we would have to look at the assets to see whether or not she is going to get support forever. And we also don't know how old she is, but assuming she's over 50, then I would say that she's going to get support really for a good 10 years anyway. Or alternatively, if she's less than that, then there has to be some sort of economic adjustment. I also hasten to say that I am not an advocate of the old needs and school that Professor Rogerson was talking about as Model 1. I do say that this situation, if you look at it carefully, sets out in classic form the facts which occur in our society today.
But Tom, Phil said that she didn't convenience herself to the husband's career. This is all she wanted to do, and this is what she did. That's a different thing entirely from what you're talking about.
Lynn, is it?
No, it's not. There's one vital factor here, and that is that she married a rich man. And I don't say that facetiously. The fact is she married this man, and if you look at the legislation, there's an economic consequence to that. She was earning $25,000. She married a man who's earning $150 or whatever the amount was. That will change her life fundamentally. There's an economic consequence to that marriage. She was living at the rate of $175,000. She can't now live at the rate of $25,000. It's just, and as well, there's an economic hardship to the breakup of the marriage. Huge economic hardship. How is she going to go back and live at a standard of living of $25,000? This is clearly a woman who needs support, and I don't know why it would be limited. I don't understand why it would be 10 years. If it's a long marriage, we're not into the duration of the marriage. At that point, you just give it to her for life, and it's that simple.
I think one of the most amazing things about this whole topic is that I've been practicing now for 20 years, and I've been involved in a lot of continuing education programs. And at no time in my career have I ever attended continuing education programs where people applaud the speakers, both sides of the issue, or usually both sides of the issue, on every time there's a question in this area. This topic has generated so much heat and so little light over the past year. However, let's take the same similar situation, Jay, where they've been married a long time, 20 years, but this time she marries a lawyer, and she too is a lawyer. And they're both practicing family law, and they're both earning $150,000 a year. And the marriage is a happy one. There are no children. She goes away on a trip down south, and she gets meningitis. And she's now completely disabled from practicing law. And the husband, as a result of her being disabled from practicing law, decides that he wishes to leave his wife and carry on with his other partner. In a more widened relationship. So, Jay, in those circumstances, and applying this economic loss theory, here is a situation that is not related at all to the marriage. Does the wife get support?
In principle, I would have thought no. The marriage has had absolutely no effect.
Never mind principle. What do you think,
No.
applying your theories? No support?
No.
Really?
Yeah.
You're a tough man. Tom, and what
Well, that's
happened?
an example of the silly sort of decision that I was talking about earlier.
Well, if you accept, and I think you do to a great extent, Tom, that what Carole Rogerson has to say is correct, how do you justify giving the wife support in that scenario?
Well, because this is an unusual sort of circumstance, and unusual cases make difficult decisions, or whatever the phrase goes. And these
Hard cases make bad law.
these type of cases are not typical and have to be decided by an innate sense of equity. And I think most of us in this room would agree that it's equitable. And within the fullness of historically the way judges exercise their discretion, that this lady ought to get some money.
Judge King, how would you deal with that scenario?
Well, I don't have as much difficulty because I'm inclined, if you look at Professor Rogerson's models, to be a Model 1 person, which is a needs and means. It's and put in some compensation. And under a needs and means model, it was a long marriage. She clearly has the needs, and he has the means, and she would get support. End of story. No
Tom?
applause. Thank you, Mary.
Tom, you want to react to that?
No, but we're running out of time, and Jay and I have discussed this on a number of occasions over a number of years, and I would like to summarize, and I think Jay would agree with this, where the essential difference is, if I can, just for a very brief period of time. Both Professor McLeod and I agree with the second model put forward by Carole Rogerson. We both agree that there is causal connection. There has always been causal connection, and we both agree that I think that Professor McLeod's annotations or comments have been misinterpreted by some of the judiciary in taking extreme positions. I think where we come to some disagreement. Is that right?
So far, so good.
All right. I think where we come to a disagreement is on 2 points. First of all, does one have to prove that there is an interdependence or a causal connection in any statistical or empirical sense in order to found the theory which would give rise to the award? I think that's one difference between the two of us. He generally says yes, I generally say no. If we do have to prove it, secondly, what must we prove? Must we go through the whole panorama of the marriage and show that she, as we used to do, that she made lobster every weekend for the man's clients? I mean, lobster salad, do we really have to show that? Following logically, Professor McLeod would say yes, I would say no, because I think that if you understand fully what the sociological and economic data has proven, you don't have to do that because it follows automatically. And I think we come to a difference in that area. But in fairness to both of us, I think that once you have adumbrated those two areas of difference, I think we can agree that the hysteria or hype, as Professor Rogerson says, about causal connection, hopefully as a result of this session today, is going to be dissipated and we can relax and go back to where we were and let things evolve in the ordinary source. Thank you.
I don't think I want to add any fuel to that fire, and I think on that note we'll end. I'd like you to move as quickly as you could to the workshops, and then we'll come back after lunch. Thank you very much to the panelists.